Our purpose here today concerns the death of Javon Riley in Manchester, Pennsylvania. Javon was almost 3 years old, having been born on January 18, 2007. On January 13, 2010, Northeastern Regional Police Department was dispatched to Javon's home at the request of his mother. Present at the home were Javon, his mother, and Javon's 1-year-old brother. Upon arrival of the emergency responders, Javon was immediately transported to the hospital. It was later determined that he had a gunshot wound to the head. Javon expired the next day after being removed from life support at the request of his parents. There is no indication that the shooting was intentional. Instead, all signs point to an accidental, self-inflicted discharge of a Walther P-22 semi-automatic handgun found on the bed where Javon lay. The Office of the District Attorney will not be filing charges in connection with this death. In making this decision, 2 questions were asked. Can this case be successfully prosecuted? To which the answer is yes. Even if the case can be prosecuted, should it be? To which our office believes the answer is no. Since the shooting was not intentional, our focus turned to the issue of recklessness, which is punishable under our criminal code. The obvious concern is how the weapon came to be in Javon's hands to cause the discharge. Specifically, we looked at the actions or omissions of the parents. It is the opinion of the Office of the District Attorney that Mrs. Riley's conduct does not rise to the level of reckless conduct required for punishment under our criminal statutes. While Mrs. Riley was aware of the presence of a firearm in the home, it was her understanding that it was kept out of the reach of small children on the highest shelf. Her involvement with the weapon appears to be a passing one, deferring to her husband, who purchased the weapon and possessed military training in its use. Mrs. Riley had no knowledge of her husband's decision to relocate the gun to a lower shelf and was unaware of the risk when she placed the young child down for a nap. Concerning Mr. Riley, it is the opinion of the Office of the District Attorney that Mr. Riley's conduct does rise to the level of recklessness required for punishment under our criminal statutes. Mr. Riley is an active member of the United States Marine Corps and as such possessed specialized training in the use of firearms. He was aware of the presence of young children within his home. His decision to place the weapon in a position where it could be seen and obtained by small children, while not intentional, was a conscious decision, and one which, in the opinion of the Office of the District Attorney, involves a gross deviation of the standard of conduct that a reasonable person would observe in his situation. The act of leaving the weapon cocked and locked with a round chambered enhances significantly this reckless conduct. Engagement of the safety, while prudent, only served to delay the inevitable result. There are no winners in this case. One can only hope that other members of our community will take notice of the devastating consequences that can result from the possession of firearms or their improper storage. That parents will pause and then act to make firearms and other dangerous items within their home unavailable to young people. The District Attorney's Office is aware that whatever decision was announced here today would be controversial. Our choice is to encourage healing instead of punishment, to promote a rebuilding of this family rather than to destroy it. We have no doubt that they could use your prayers.